Elective-share statutes allow a surviving spouse to take a percentage of a deceased spouse's estate instead of whatever the surviving spouse would receive under the will. In Shimp v. Huff, we explore the intersection of a current spouse's elective-share right and a joint will between former spouses. While married, Lester and Clara Shimp executed a joint will, with each spouse leaving his or her estate to the other, subject to a mutual agreement that upon the surviving spouse's death, that spouse's estate would be distributed to certain named beneficiaries. The will specified that it couldn't be altered by either spouse after the other's death. After Clara died, Lester petitioned for a declaratory judgment stating that he could execute a new will. The trial court concluded, and the Maryland Court of Appeals agreed, that Lester could execute a new will. But because the joint will contained a contractual agreement, the intended contract beneficiaries could seek specific performance upon Lester's death, enforcing its terms. Consequently, Lester didn't revoke the joint will. He later married Lisa Shimp. When he died, the joint will was admitted to probate. Relying on Maryland's elective-share statute, Lisa sought half of Lester's estate, but the estate's personal representatives, Mary and Wallace Huff, declined to pay. Lisa then sued the estate, seeking declaratory judgment that she was entitled to an elective share. The trial court concluded that because Lester contracted to dispose of his estate before marrying Lisa, there was no estate from which Lisa could take an elective share. The Maryland Court of Appeals, as the state's highest court was then known, granted review.